Okay. Good morning. Can you hear me? Hope you don't mind the seat. I have a problem with my right leg. It would be difficult to stand. I just remember that I came first time here 40 years ago. It was 1982. I was a teaching assistant, and there was a similar kind of event, but different. It was organized by State Florida University. There was a Professor Matjašić, originally Croat, who was professor in Florida, and professors were from ex-Yugoslavia, including my ex-professor, Professor Ivošević, who invited me. So it was a different event because now we are more international now, 40 years after. Scholars from different countries, students from different countries. At that time, all students came from the United States. That was the beginning of my academic career, and now coming to the end of my academic career, I'm going to retire next March. So this 40 years, looking back, was like very fast, but many things have happened those 40 years. Around that time, I bought my book, first book in English, Roy Good's Commercial Law. And I would not even dream that I would work with Roy Good. And a few months ago, he sent me a mail. He's editor of well-known book, Transnational Commercial Law, and I wrote a chapter of that, Courage by Sea, and then I'm going to write another chapter because we are going to have a third edition probably next year. So you can see this kind of developments, something I was not so good at English, 1982, and now I write books in English. One thing that, because I'm probably the oldest here, I'm certainly the oldest, one thing that strikes me is how the history accelerated during those 40 years, particularly with IT, with computers, with internet. Because now I'm communicating with Roy Good by email. That was unthinkable 40 years ago. I wrote my first master thesis using typewriter. Very frustrated. Who used to, now it's like museum typewriter. I have still at home my Olympia, and then you make mistake and then you walk around. And I wrote my second master thesis using Japanese, call it word processor. It had some memory, so there was essential functions, cut, copy, paste that existed, but of course far more primitive than what we have like this computers now. So things have changed at fast pace, and one of those aspects relates to today's topic. It's about e-commerce and blockchain as a kind of new stage. This is my university. I'll show you where is my office. Here I have view to sea, and I can see some ships. It's a new campus. It's a bit far away from the city, and I will stay for 2 more years after retirement because of blockchain. Every year we have a process of application for grants by Japanese Ministry of Education, and we are encouraged to apply. And last year I was thinking which topic would be convenient to get a grant. And always you try to find some hot topic, hot sexy topic. I came to the idea maybe blockchain because I specialize in transport documents, bills of lading, and this is kind of step farther. And I thought that since I have background in transport documents, maybe I can jump to blockchain. So I'm not really differently from Patrick. I'm not deeply in this because I got my reply in April, and from April actually I started to seriously consider these issues, and I wrote one paper, and I will have presentation next month in October in Rome. Roy Good will be there. So this transnational commercial law network, and I'm planning another paper, something related to possession, and UK. England and Wales have issued a law commission report about this kind of issue, and there are 1 or 2 slides about that. So this is probably my next topic. But let's start with today's topic. Okay, start with the cow, because all so far was based on paper. All documents were on paper. There is no legal requirement which would say your documents have to be on paper. But paper was the most convenient way. Otherwise, it's nice humor by Swedish professor Kurt Grenfors saying legal promise could easily be written down with black ink on a white cow and still be legally valid. The main reason why we don't use such a method is, of course, that is the most inconvenient to have once promissory notes feeding on green pastures. Of course, this would be legally enforceable because law does not prohibit having this kind of promissory note, but who would go? You want to take taxi, you cannot take your cow to taxi. So paper was used because it was most convenient. And things started to change with the introduction of computers and internet. Now there was a possibility that paper is not necessary anymore. And the paper is expensive. It causes a lot of costs, has an environmental cost as well. And it's slow. In case of bills of lading, this is a serious issue because one of the most common problems with bills of lading is that the ship would arrive at the port of destination, but bill of lading is somewhere else. Particularly when you have resale of goods in transit, the goods can be sold several times, and bill of lading is somewhere in the bank with processing letters of credit. So the ship is at the port of destination, but the buyer cannot get the goods because the buyer does not have a bill of lading. With electronic bills of lading, this problem would be solved because you get it immediately. And very likely, letter of credit would disappear in the present form in the future. My paper is entitled Third Stage, so maybe it's new generation. Maybe it's we should start with a little bit of history. How was in the past? What are the stages of development of electronic commerce? I've tried this kind of approximate, so please I will use disclaimer. It's not precise dates, approximately. First period 1980, but maybe a little later, 2000, and first step was so-called electronic data interchange. That was beginning. Second stage was what we are going to discuss today, one slide, so-called registry.
Muted. Okay. Minimize this. And we have to share. I'm sorry. Would you have up here? Huh?
Yes. So second stage was based on registry system. There is a trusted third party who will be in charge of transferring rights between the parties. And we should have one slide I will explain in more detail. And 2010, now there was a so-called Satoshi name, Japanese name, but nobody knows who is that. Okay. Satoshi Nakamoto, probably pseudonym of someone. The blockchain was launched. That was the beginning of blockchain, but it was not. It was more related to cryptocurrency, bitcoins, and more recently, now there is a development towards using more widely, more broadly, including transport documents. And for each period, there were, because there are different legal issues, and each period was coupled with different legal reactions, and we shall see in the following slides. EDI, electronic data interchange, exchange of digital information where data is structured in such a way that it can be automatically understood by the soul. That was the beginning of e-commerce. It was a while ago. I wrote one paper. It was my first paper on this area, 1997, I think, something like that. And there was one important legal development following EDI, that was Untitled. Untitled was very active in this area. It had its own working group on electronic commerce. At the time, there was this model law on electronic commerce 1996, and two important principles were incorporated in those principles. One is functional equivalence. That was very important. Instead of creating a new legal framework for electronic documents in a very pragmatic, practical way, Untitled decided that existing legal framework should be extended to cover electronic documents. And technological neutrality, because technology is developing so fast, there are new technologies replacing older technologies, so there should be not linked to any particular technology. It's open, kind of open system. And there was one article addressing actually transport documents, but that was not very useful. It was ambiguous and not really used in practice. What were issues at that initial stage of electronic commerce? Main issue was about legal validity, legal recognition of those electronic messages, because there were different rules in different countries, different national laws. In common law, they have one important part of civil procedure relates to admissibility of evidence. In civil law, we don't have admissibility. Everything is admissible. Weight is an issue. What weight you can give. But in common law, you may have seen on movies, objection. This is not admissible. Hearsay, you don't have direct knowledge. Somebody told you this is no. Best evidence rules. So these are the kind of rules that should have been resolved obstacles in order to recognize legal validity of electronic messages. In civil law, focus was more on signature, original. That is the concept that we are familiar in civil law. Is it original or not? And how you can prove originality is by signature. So that was the direction of law in that first stage. So civil procedure rules in UK, in the United States, have been revised, basically providing for certain criteria, standards that should be fulfilled in order to recognize legal validity of documents. So if something is which was mainly focused on whether computer system has integrity, so you can prove that it cannot be altered by someone else, because that was the issue. Data in computers can be easily altered, but if you have some security mechanism that ensures that data protected, it becomes kind of original in electronic way. And then there was also law on electronic signatures, Amsterdam model law, and many countries have adopted national laws on national signatures, on electronic signatures. Actually, the first master thesis I supervised in Japan was by a Thai student, because Thai at the time has adopted law on electronic signatures. So these were the beginning of electronic commerce, technologically and legally. And we are coming now to our topic, that's about bills of lading. And I'm sure you know that bills of lading have three main functions. Original one was receipt, by delivering the goods to the carrier. Carrier would issue bill of lading to the shipper, evidencing, certifying that the particular goods were accepted for voyage. Second function is evidence of contract. Bill of lading is not contract because it's signed only by carrier or on behalf of carrier. Shipper does not sign bill of lading, so it's not contract, but is evidence of contract. So in case of dispute, you would look on the back of bill of lading to see what are terms and conditions of the contract. And third, and something which is actually the most challenging maybe for e-commerce for people to solve, is document of title. By having a bill of lading in your hands, you have the rights that are embodied in document. Just one remark about the terminology of document of title. In civil law, we don't have document of title. We call it document of title, but that's not document of title. Document of title is common law term. Common law has different kind of documents. They have negotiable instruments, which is something which gives you the right payment, like promissory notes, bill of exchange, check. These are special category of documents called negotiable instruments. Then there are negotiable documents, like bill of lading, warehouse receipts. Document of title is actually one of those documents. And then you have some other categories like shares. In civil law, we have only one and only vrijednosni papiri. That's the concept. Wertpapiere, what Germans would say. Titoli de créance, titoli di credito in Italian, yukashoku in Japanese. Something which is more, I'll say, kind of umbrella under which all these documents stand. This is different because of different logic between civil law and common law. Civil law is has this kind of broad concepts like good faith. I think when Peter Kragic was saying that English don't like good faith. Why? Because they have something different. They don't have this kind of broad concepts. They have only in insurance, they have good faith, utmost good faith. Otherwise, in contract law, there is no good faith in English law. America is a little bit different law. So they have this kind of broad concepts in civil law, which is in line with the logic, with character of civil law, which is based on deduction. So here we start with general principle, and you go to something. So this apple is green or red, then all these apples are green or sweet. Common law has an opposite logic. It starts from something particular. This apple is green, that apples are green. You create a general principle. So this is that is my explanation of different approach between civil and common law. So in common law, you don't have good faith, but you have estoppel, you have mitigation, you have misrepresentation, this kind of concepts which correspond to good faith, because common law has a preference for this narrow piecemeal approach, in contrast to civil law, which has a different character and different logic, it's more broader. So document of title, just I wanted to clarify this. Document of title is a common law term, but it's used, everybody uses it in civil law because this is more simple. It's kind of, instead of explaining this kind of differences, just use a document of title. A paper bill of lading, that's important point. Is capable of playing all these functions, these three functions, not because it is on paper, doesn't matter, but because of what it represents and is capable of doing. And when it comes to replicating the functions of bill of lading, there is no problem with receipt and contracts, because we have a lot of electronic contracts. Many people in Japan now, I'm buying on internet. There's no contract now. There is no problem of evidencing or anything. The problem is with document of title. Why? Because document of title is based on transferring rights by endorsement. Which mean you write on the back of the document who is a new holder, who has a new rights, who is transferee. So you have to write it on paper, and this is something which is linked to tangibility, to physical possession of the document. And then that is the issue: how to replicate physical possession, how to find a way, electronic way, that would perform the same function as a document of title, a paper document of title. So I like this because there was a chaos on there. I'm sure if you heard about, if you remember Dolly, famous sheep Dolly, cloning, because there are different terms. I like this cloning because it's same, but the clone is probably similar to what is actually the point here, that you have to clone the function of document of title, transferability. And that, as I said, only something which is tangible can be physically transferred. And So we are coming to the key point, to core point, how to find a way that there is a kind of a new type of document which will be intangible and still transferable. Not on paper, but in electronic way. So all attempts at replicating or cloning this transferability function, document of title function of bill of lading are focused on this, how to find a way to replicate physical possession. Because other two functions are not an issue really. Of course, there are some issues, but it's not so difficult. Possession right of control. So this is a kind of change. Right of control, as far as I know, was not used in national laws. It's first time I remember that I found it was in Rotterdam rules. Rotterdam rules has a right of control. And why? Because Rotterdam rules also deal with electronic documents. So this is first legislation, attempt at legislation that addresses international legislation that addresses the issues of electronic transport documents. So there was because possession right of control are very similar. Possession is by having a document in your physical possession, you have the rights on which are embodied in documents. A right of control is basically what you have, and right of control is a right to dispose of the goods, right to transfer the rights in the goods to someone else. As a seller, you transfer a bill of lading to someone else, and then you transfer the rights to the goods. Or it may be possible that you have different way by giving instructions to the carrier. In case of non-negotiable documents like CVA bill, you still have possibility to control, but not by transferring document, because CVA bill is not document of title. It's non-negotiable. But in that case, you have another way, that is by giving instructions to the carrier, you still retain control of the goods. Yes, like this German saying, das Recht aus dem Papier folgt dem Recht am Papier. The rights deriving from papier actually is based on your right on the papier. So by having paper, you have the rights which are embodied in the paper. That is the main idea of vrijednost papir, of document of title, of having possession. So you have to have it in your hands. You must be, as often is said, you must be lawful holder of the document, lawful holder of bill of lading, which gives you the right. Because if you steal bill of lading, just holding it's not enough. You must be lawful holder of bill of lading. And of course, for that, you need, that is an issue. Holding in your hands means that you have it, something tangible, you have paper in your hands. And that's kind of the key issue, how to find a way that you still have the right of control without possession of the document. And a new concept that I found in some documents, this legislation is exclusive control. So the concept of possession, there is a tendency to replace it by exclusive control, which is a functional equivalent of possession. So instead of having possession of some electronic document, you have exclusive control, which means that only you and only you, is a Platter song, only you have the right. Nobody else can have access to the rights. You are the only one. And this is more focused. The focus is different. In case of possession, it's focusing on having identifying yourself by having a paper in your hands. In case of exclusive control, it's a different way, because you don't have it. It's not tangible, but then you have exclusive control. And then the issue is how to come to that point that you can have exclusive control. Must be something which is often something which was similar to this concept of replacing original by electronic. It's kind of you have to find reliable methods that which guarantees integrity. This is something which is of essential importance, reliability. And we come to first instrument that addressed the issue of electronic bills of lading, CMI, uniform rules 1990, which was an important step, even if did not have much practical relevance. Don't think anyone used these rules, but it was a first step which opened door for further development. And one very important concept that was introduced by CMI rules was a private key. Private key and public key. Public key, that's something which is now also in case of blockchain, you have something similar, no? But that was introduced by these CMI rules. So the one who has a private key has exclusive control. And the problem with CMI rules was that few problems, but the main problem was that this task was given to the carrier. The carrier is the one that who should distribute a private key. And this was, I think, from the beginning, this was a problem because carriers are not IT specialists, they are specialists for carriage. And this means if you take this kind of task, you take additional responsibility, additional liability, and carriers don't like that. Why we should take responsibility for transferring rights? It's not our job. We are just carriers, we carry the goods, we don't want to have additional liabilities. So from the very beginning, I think that was a key problem. And the private key itself was not transferable, but because carrier would actually be in control, and you inform the carrier, and carrier informs new party what is private key. So there was a kind of flow in the system. These are 2 points which make it unworkable. Next stage, this is stage 2, registry model, which is functioning today. There are several this kind of registry models, which relies, instead of having carriers, which was, as I mentioned, that was not workable, you have a trusted third party. We started with one banking, English bank, but did not last for long, and something which was more successful, and you can see this Bolero and this docs, which are functioning, have a number of participants. It is a closed system. You have to become member and you have to pay fee. And legal validity of documents is not challenged because by signing Bolero book, by signing agreement to become member, you have to sign agreement. You give up all claims that you might have, that this is not a valid document, this is not a document of title or that. So as far as I know, there was no single dispute arising from this closed network. So it's working. If you enter their websites, they would say we are very successful. But there are problems. First of all, it's closed system. So it works only between the members. And sometimes you want to sell the goods outside to someone else, and then you have a problem. This would not work. Then you have to switch to paper. So that is, and then cost is an issue. And as I just told Patrick, the real solution for this problem is open system, because bill of lading is open. You don't have any membership. It's open, and that is actually something that I still don't know. And this is something to discuss and find a way how open system, open blockchain system can replace this paper bill of lading. Because several blockchain systems are closed system, and this is something very similar but different from a register system. Very similar but different. I'll tell you later what is different. Okay. Yes, a lack of legal recognition, that's something that will come later, because national laws do not recognize electronic documents as valid as document of title. American law has changed, we shall see later, but many national laws, and that particular issue with English law. Under English law, electronic documents of electronic transport documents are not recognized as documents of title. And of course, when this gives kind of legal uncertainty, and people from practice don't like that. They want to have predictability and certainty. Token-based, I assume that you know what token is different. Token is a know what's token. For example, you go to theater and you leave your code and you get a number, and this number is your token. You go back after drama, whatever opera, and you show your number and you get back your code. So this is a system that works without this kind of third party. Because it's instead of identifying person in the other way, it's actually the holder, the one who has something in possession. So it's kind of very close to possession, and that is the issue. How can replace without having suitable technology? How token can replace bill of lading? And actually, that's what I brought at the end. The blockchain may change this. Okay. So that's something what is different in blockchain. Actually, it works that way. Blockchain is based on kinds of token between the members of the network. The token, the right to something, to currency or to goods, can be transferred. And we come to what is the main topic. It's blockchain. As I mentioned, I'm just a beginner in this area, so I still have a lot of unknown, particularly when it comes to technology. I'm learning process. It's my first year at blockchain, but of course there are a lot of writings, so you can learn from not only legal writings but also people with technology. So if you make efforts, you gradually you can grasp the meaning of this. So it's new generation. And it relies on tokens. So it's not third party, because there is no third party. It's open system in a way. Everybody can become with some if you have some knowledge. And that is actually the key point, the key advantage, because in the beginning, once someone mentioned that blockchain can be used for bills of lading, one colleague said, how? Because for me, that was something related to cryptocurrency. But then when you enter gradually into that with some new developments, it is possible to have a transfer, not only rights to payments like cryptocurrency, but also you can have a kind of assets that can be transferred between among the members of the network. And the holder can have a kind of control over blockchain through digital identity, and that's important to exclude others, because that is something which relates to exclusive control. It's only you that you have right to control the right to the goods. So this is opens the way that blockchain may replace paper bills of lading, because the logic is very similar, just the way how it is done is different. So a few things about blockchain, just as a kind of general background. What is blockchain? So it's kind of electronic logbook. And why it's called a block? Because kind of blocks are created based on previous transactions. And there is a database that contains records of previous transactions. So each block is chained, that's why the term blockchain is used, to the next block. And something which is very important is security hashing. One issue that I have some reservation is because this requires some knowledge about technology. And one issue that I did not prepare this, but I'm just thinking, if you want to have a widely used system like blockchain, this would require that people learn about blockchain. And is that an obstacle? Because for large companies, this is no problem. If you have basic knowledge of software and you have an IT man in your company, that is not problem. But if you have small merchants without basic understanding of blockchain technology, can that work? Particularly in initial stage. Initial stage, they might be reluctant maybe to spend some money or just to learn about these things. But I think this would eventually be resolved, because same as computers, people are used to old ways of doing things, and at initial stage, they're reluctant to give up and to switch to something else. It's human's mentality. But I think even if I have some reservations, eventually by the time this would be resolved. But I think initial stage might be some problems in invite use of this technology. So what is important is that there is kind of public, same as CMI, public key cryptography, which plays important role, and public key is available to everyone, and private key. That is something that is attached to a particular party who has the control. And again, you have digital signatures. So basically, everything was step by step building on already existing legal infrastructure. So it's not something completely new. You have the digital signatures earlier. You have private key earlier. You go further and make further steps in the process of building a new technology and new legal framework. It's not that you take something from scratch, from zero, but already you have something which existed in previous stages. And what are main features of blockchain technology? There are three main that you usually find in this text. This is decentralized system. So there is no central registry like Bolero or something like that. It's peer-to-peer network. There is no single part. There is nobody is in control. With some, again, in some system you would need kind of membership. There's some kind of closed blockchain system. I think that this is something similar to registry. But again, it's different from, because even in that case, you don't have kind of central registry. And that is what makes difference between closed system, closed blockchain system, and central registry system. Pseudonymity, it's not really anonymous, but use some names, pseudonyms, and that's why it's called pseudonymity. So why is pseudonymous? Because identity of that person is not known. People say with some technological knowledge you might be able to reveal, but probably it will take some time and some knowledge. And very importantly, immutability, which is based on cryptography as a technology, which is designed to create secure and immutable records. And I wrote virtually impossible, which means it might be possible, but very difficult. But that's something, even in paper, you don't have absolute security. Who guarantees that someone would not falsify bill of lading? You just use your left hand and when signing, and that we have that kind. So there is no, in general, in practice, there is no absolute security. And what is required is to come to the level of something which is reasonable security. And I think blockchain offers that level of security. It's not so easy. And as I would say, it would be easier to falsify paper documents than this kind of electronic technology. Document of title. Yes, and we come to that again several times. We come to the same point, how a blockchain can play this role of, because it cannot be physically possessed. And token actually as a system is a way of allowing this kind of function to operate in the system of blockchain. And private keys are actually key to this, because the one who has a private key has the right, has exclusive control over the rights on the goods, and has a kind of exclusive right. Only holder of private key can initiate transfer of rights, because this is something which again, it's what Rotterdam rules calls right of control. You have right of control, and actually possession and right of control are two sides of the same coin, because possession actually gives you control. And the issue is whether you need possession or you can replace it by right of control. And we shall see now, we shall come later, that English have preference for possession. They insist in this law commission, they insist on possession. And that is something that, for me, it's quite intriguing, and maybe my next paper will be about that. Do you really need possession? Because what you need is to have something that can play the same function, not necessarily in the same way. But I think for some formal reasons, because possession is an essential concept in English law, they try to extend the meaning of possession to include electronic documents. Okay. Public on private. Yes, so we come to that point that blockchain can be either public, or it's permissionless is used, which means you don't need authorization, or you need a kind of private. That means you can participate, but it has some similarity to the closed system. And yes, as I said, private system is similar to registered model, just you don't have trusted third party, but you need a kind of authorization. I think some parties may have preference for a closed system or this private system, particularly banks. So there are concerns about security. That's what I read about in some papers. And what I believe in is that public, this permissionless blockchain is the real way to the future. Because that way you would have open to, that is the way that you can replicate what we have now at paper goods already. When you have closed system, private system, this is different. This is something similar to registered system, but this is still kind of closed system. And in order to have, if we intend to have a system to replicate the current paper documents, the future is in public system, permissionless system. This is how to do it. That is something that the solution is still not found as far as I know. But CargoX is using something similar. It's kind of public system. No? New generation. So replicating functional documents, that's actually what is important. Not necessarily tangibility. You don't need tangibility, but what you need is that this kind of new electronic document plays the role of document of title. And which means entitles holder to claim the goods by having this private key. You shall see later how it works in practice. And holder you can dispose of the goods by transferring your exclusive right, because you are as having a private key, you have exclusive right. And alternative is creates possession and transfers the records, and that's important, excludes others, because these are essential ingredients of document of title. There can be no several holders of the same rights. That's why, as I mentioned a few times, only you. Which means this means you exclude others from having control. That is of essential importance and once you transfer, there should be no reversal. You transfer, you cannot get it back, because otherwise this would be kind of unjust enrichment that will be abused. Transfer of possession control is control of token, possession of the goods should be the same thing. And possession of a token of control enables transfer of blockchain bill of lading. And this is something which corresponds to the transfer of paper bill of lading. Digital signature, one-way hashing, these are technologies, private key. These are methods that are used to prevent, it's kind of security methods to prevent tampering of the records, to secure that, exclude others from access to the right. And transfer of token in the form of chain of digital signatures. Always you have digital signatures, which is based on kind of complex mathematical operations, algorithms. So you need, that's what I'm saying, you need kind of technological knowledge in order to use blockchain. Yes, it's compatible with notion of control and possession. Reconsideration of the concept of control. Control has not, still it's not legal defined, because everything was based on possession. It's probably English still insists on possession, because in English possession is well-established concept, while control is kind of a new concept, which serves as functional equivalent. I think that is the core issue, whether you should use possession as traditional concept or control as something as functional equivalent of possession. So that's something that I'm thinking about, the topic of my new paper. So functional equivalence can be achieved different ways: registry, like this registry model, token, and blockchain, which are three ways. But blockchain also includes token as a way of transferring, right? Because it's the one who holds, the holder of the key is actually the one who has the right from the document. So these are several attempts in practice. This is about practice. You can see There are several developers. I think there is one more from Congo launched recently. Wave Cargo X. I think Patrick will tell you more about Patrick X. You can see, you can compare them. You can see that there are some differences. The key difference is that Cargo X is a kind of open system, but all others are private. You can see also there is some. This is prepared by my colleague. So he checked all this, and so there are some fees that you have to pay. A liability, that is something that will arise and not really so far addressed properly. What happens if there are some errors, malfunctions, abuse, hacking? So there are some issues about security, and importantly, P&I clubs have covered liabilities arising from this kind of electronic transport documents. But is the case, this cover is limited. Cover liability is available for P&I liabilities arising under any electronic bills of lading, to the extent these liabilities would also have arisen under paper bills of lading. But it's important that P&I has given kind of recognition, and this gives kind of security to the parties. Legal framework, as I mentioned, Rotterdam Rules was the first international instrument that addressed the issue of electronic transport documents. It has one part on electronic transport documents, and introduced the concept of exclusive control as the functional equivalence of possession. And there are several provisions. Article 8b, the issuance, exclusive control or transfer of the electronic transport records has the same effect. So it's kind of functional equivalence as possession of transfer of transport documents. Okay, so this is based on the concept of control or exclusive control. Even in paper documents, they use the concept of right of control, while in case of electronic documents, they have this kind of exclusive control concept. And an important development, because Rotterdam rules most likely will never enter into force. It's low chances, and even if they enter the force, I don't think they will be widely accepted. So my personal view is that it's better than never enter the force, because this would lead to greater fragmentation of law governing carriage by sea. Now we have Hague rules still valid, applied in the United States. Hague-Visby rules apply in Europe, many countries, and Hamburg rules. So if we have, in addition, Rotterdam rules, we would have not 3, but 4, which would make things worse. So my opinion is that I hope that Rotterdam rules would never enter the force. Otherwise, we would have more problems, more difficulties, more legal uncertainties. I think from the beginning, it was a failure in the way how it was drafted, as I mentioned when Petar Kragic has lecture. The easiest and the most the way that would give the best chances to Rotterdam rules was simply to expand the Hague-Visby rules, to modernize, to add part on electronic documents, because otherwise, as Petar mentioned, all those case law which was crystallized practice over how many years, almost 100 years, would be given up. You would have to start a new case law, and nobody likes that. Particularly practice doesn't like that, because, as I mentioned, practice likes predictability, legal certainty. So I think, in addition, what I mentioned, it's some provisions are very difficult, complicated, too long. So I think Rotterdam rules very likely will never enter the force. Even if they enter, they would. So, but that was important. Still, they made important progress with regards of regulation in electronic transport. That part, I don't have objection to that part. I think it was a smart way to address electronic transport documents, so it can be used as a basis for some other legislation. And another important development is this model law, ancestral model law, adopted again by Ancestral 2017, which, as the name says, is supposed to serve as the model law for other countries and the main objective is to create legal basis for recognition of electronic transport documents by adopting national laws. And I think this is a much better way and some countries have already adopted national laws. I think on the second slide, I named those countries. And it's based on something which already existed, technological neutrality, something which we found in Amsterdam Model Law from 1996, because technology are coming, we have blockchain, and functional equivalence and exclusive control. So these are three main principles. One problem, not sure how serious, is with Amsterdam Model Law with regard to blockchain. It was adopted 2017. At that time, blockchain was not widely used. So if you read the contents, and if you have interest, I encourage you to have very good explanatory notes explaining each provision. You can see that the main focus was on the registered model, because that is something that existed at those days. Blockchain was just starting. It's mentioned somewhere, but the whole concept of this model law was based on the registered model, not on blockchain. I'm not sure how is there any bad effect of that, but my opinion probably would be better that was adopted a few years later, when blockchain becomes something reality, because that time was just beginning of use in practice. Yes, these are concepts, uniqueness and singularity. Document must be unique, and there must be only one document that gives right to the goods, which are distinguishable. As same is the case of bill of lading, you have copies and you have original. And I think that was a smart decision that this model law, instead of uniqueness, switched this concept and replaced by singularity. I think that's more suitable for electronic transport documents because that requires reliable identification of electronic transferable records. And something which is important, there is I didn't want to spend too much time on the model law, but I will just tell you. One important, I think, is Article 12, if I remember correctly. It's about reliability. It's quite a long article. So it means that a lot of attention is given to this important concept, which ensures that this kind of documents can be used, would not be tampered, altered, and all abuses can be avoided by having various technological methodologies that prevent documents from being tampered or altered. What is potential impact? Yes, it depends how widely would be accepted in the practice. And when it comes to adoption of this kind of new instruments, it depends very much on business, whether there is a pressure from business to adopt certain legal instruments. And the issue is how strong would be the pressure in particular country to adopt something similar to this model law. So some countries have made already the choice, adopted laws, and we should, I think next slide is about, in a few slides, about UK. So UK is considering that will be major issue if England adopts the law. I think it will. Then we will have something really new. Yes. Transfer records retain legal effects, and I should, okay, these are something that I already told you about this. Prospect. Yes, as I mentioned, will depend on level of acceptance, and these are countries that have so far adopted national laws based on this Amsterdam law. Abu Dhabi, Bahrain, Belize, Paraguay, Singapore. And important developments, that is something, of course, these are, of course, Singapore, okay, it's an important country, but these are not major jurisdictions that can make impact. But US and UK are different. US has revised its UCC, Informal Commercial Law, Commercial Code, and now they recognize legal validity to electronic transport documents. We have section 706. Control of electronic document of title. So something which England is struggling still, you have it in your United States law. Electronic document of title. recognized very clearly. A person has control of an electronic document of title if a system employed for evidencing the transfer of interest in an electronic document reliably established that the person is the person to which electronic document was issued or transferred. There are a lot of provisions, long provisions in this article, so and this is the most important. So you can see that the United States has paid attention and has made important steps. And this is very important because when a major country makes this kind of change, very often this is kind of like avalanche. You start with small part of snow and then it, like Harteract was a lot. National legislation can have that kind of impact. So it's very important what the United States has done and what UK or England and Wales, Scotland is not here, not Northern Ireland. It's a law commission representing interests of Wales and England. And that is something that is really interesting and important. They published a report in March this year, long report. People who have interest in possession have extensive explanation of what is possession. So if someone wants to write masterpieces about possession, we can learn from this. I think maybe a bit exaggerating this discussion on possession, maybe too many details, but of course, the point is they wanted to justify the use of the concept of possession. Because in the report, you could see that, for example, Roy Good, Michael Bridge objected to the concept of possession. They said control is enough, because at the end you will come to the point of control, and that is what I mentioned. That's probably I shared similar view. What is important is not to have exactly the same way as paper, but to have exactly same or as much as possible similar effect, legal effect as a paper. And control actually can achieve that. And there is no problem with this Amsterdam model law in other jurisdictions. But apparently, and that's explanation, English law, you need to keep possession if you want to recognize a document of title. Because in English law, basically only ship bill of lading has clearly achieved the status of document of title. In English law, you can do it either by legislation or by merchant customs. So merchant customs was the way that bill of lading was recognized as document of title. And without that, it's not possible. So that's in one of these cases, there is one more case. There is suggestion that there should be legislation prepared so after consultation by law commissions. Your respondent data team, business media, 2015, the judge said, we have not, our hands are tied, we cannot recognize this as document of title. The only way is to have legislation and to be prepared as by law commission. That is the reason that law commission actually, you can see that in UK there is this interest, obviously, to go a step further and to recognize electronic transport documents as a document of title by legislation. Most likely by revising maybe Carriage of Goods by Sea Act 1992 or creating new law or something. They call this all this bill. But bill, what does mean bill? Probably there will be kind of, it's now time for discussion. It was opened and actually in the process of drafting this bill, Law Commission has contacted many people from practice, scholars, and it's obviously it's a very serious work. So it's it's quite interesting for scholars that maybe because still it's kind of under discussion, it's not yet to the Parliament. So if you want to express some views about this, I think you are welcome to. I plan to continue because I found this topic quite interesting. I probably would address that issue. Do you really need possession or control would be sufficient? Of course, I have no problem with possession. It can work, but do you really need it? That's something that, because if you want to achieve international uniformity, you better stick to the same terminology. In US, they didn't have problem with control. Singapore has no problem with control, but UK or England and Wales, they still want to stick to possession is the concept. Basically, that's yes, main points of report. And another issue that I have problem with, probably I would address, they use a closed list. So only those documents are, and they call it a paper trade document. I never heard this kind of expression, paper trade document. And the paper trade document, actually, they put something which is very similar to verpapiering, vrijednost papir in our law. Something, because you can see it's a bill of exchange, promissory note, bill of lading, warehouse receipt, marine policy, mate receipts. Mate receipts is there. Is mate receipt vrijednost papir? I'm not sure. I would have some doubts about that, but in English, obviously, it has that kind of status. So they created a new concept of paper trade documents to be replaced by kind of electronic trade documents. So issue is one issue is how different is from this transferable records. The term that is used by Anstel model, is it same or similar? Why? Because transferable records is open list. This is closed. Why closed? Is checked because check is not there. Why not check? So I have some doubts about this. It's another point that probably I would raise when I write my paper. Why close list? I think open would be better. Kind of you create criteria for documents that would be admissible, not create only these documents, nothing else can qualify. And yes, the key point is that Law Commission idea was to expand, to extend the meaning of possession to include electronic transport. And that is something which is required. That's actually the key point. That's a key objective of this report, that electronic transport documents are recognized as document of title by legislation, and then becomes law, and it becomes it acquires legal effect. That was actually the main objective of this law report. Okay. So these are some issues, but if you want to have more knowledge, it's very detailed explanation why possession, not control. Yeah, so we have a cow, we had sheep, now it's chicken time for chicken. The issue is about legislation. Normally, usually in practice, demands come after some practice is developed. Usually business comes first, normally. You have some practice developed, and then at a certain point you want to legislate to make it orderly, to avoid any confusion, uncertainty. But I'm not quite sure about this particular case. Why? Because practice is stuck, it's stopped because of lack of legal recognition. So I don't think there is a need to wait. I think in this case, it's not who comes first, chicken or egg. I think both should make steps in direction of achieving the objective that electronic transport documents can replace paper documents. So I don't think we should stick to this traditional way, practice first, law comes later. I think both should make attempts, efforts to create possibility, open possibility for commercial use of electronic transport documents. I think that should be the objective of all. And eventually, when we come to a certain point, very likely there will be kind of international convention. But we show that that's enforceable features. They are still far. Thank you. Some questions?
Are there any questions?
Yes.
If you want, and around the beginning of the presentation, that you were talking about the uniqueness of electronic trading, and the thing that the issue that it is easy to duplicate. Well, nowadays, I will often try to learn something about blockchain, but it's really a really long way to understand it. But can a bill of lending can be used as an NFT, like a non-fungible token, and in this type of situation, even when you copy it, you didn't duplicate it. I myself don't understand it, but the thing is, even if you have the exact same copy, only the original one would be classified as a unique. So
In case of paper bill of lading, you can have several originals, which sounds a bit strange. Huh? Bills of lading are issued in 3 originals traditionally, but still they're originals in the way that once the goods are delivered against one bill of lading, the other, you'll find in every bill of lading, once been accomplished, the others to stand by. And to avoid, because this is also about originality and uniqueness, there is a unique, only one original bill of lading, but issued in several originals. And you may have several copies in addition, but in order to avoid, because obviously there is a risk, and there are cases in practice. I remember one Chinese case that was abused because of problem with Chinese law. In order to avoid the risk, then you may have several holders which would come at the port asking for delivery. In letter of credit, you demand a full set of bill of lading. And once bill of lading you deliver against one bill of lading, the others lose validity. What was problem in Chinese law is that on the way, the shipper change instruction to the carrier, and under Chinese law, you can do that if you return bill of lading. But there were 3 bills of lading. One, he sold the goods to consignee, and then after he got money from consignee, he gave instruction to the carrier. Under Chinese law, that's possible because you don't have to return all bills of lading, like in Japanese law, in German law. In order to have the possibility to give the instruction to the carrier, you have to get back all bills of lading. Under Chinese law, it's singular. You return bill of lading, you have the right to return. Of course, this is a gap in Chinese law. I know the name of the case, I can tell you. So this is something that should be avoided also in case of electronic. You have to have a current guarantee that excludes others. There should be only one person who should have control. So I think the same logic as in case of paper documents to avoid this kind of abuse that happened in paper bill of lading.
Only one person at a time. So if I send it to someone, now I hold it and I can send it to someone else and the one from the source and do anything. I have a before, like we bought some picture or whatever we buy with the art. So do that analysis and distant.
Yes, and also it's important to prevent this reverse. Once, same as in Chinese case, you transfer the right and you cannot get back and still have the right of the control. So that is something which is guaranteed by the system.
Which is even better than the
yes.
Because this theory is not, and legal is out of this theory. I never really get it right. The originals,
it's history.
Sometimes by two different ways of sending the document because it was not true. Right.
Exactly. That's a relic of history. It's history because once upon a time you didn't have security that one bill would arrive, so you would send by different ways. So and as a relic of that historic practice, we have this kind of archaic way of that bill of lading is issued. Of course, when you say original should be one, but bill of lading can be issued in 3 originals. Yes, because possession gives you the title, it gives you control, and then the issue is why you need possession, like this law commission. And the explanation is not so convincing, frankly, but they try a lot of efforts to prove that possession is really needed under English law. Because probably
someone who is far away from the paper is in a possession. So that's the point of control.
Yeah, control, yes. So that's why very good. Yeah, you can find on internet the report. So you can see that they contacted very good and Michael Bridge, leading authority, and they said control is sufficient. At the end, you would come to the point of control, title and possession. So I don't think there was a need for possession, but they insisted for some reason using, they're explaining like control and exclusive control, it sounds a bit weird in the same sentence. So no, but just to achieve kind of uniformity, because possession means something that you have, and control is that you have control. So in case of electronic, it's more closer to what is to the facts that you don't have in your. It's not that big issue, frankly. It's because possession can work. That's certainly, I have no problem with that argument. Possession can work in practice. I see no problem with that. As Roy Good, Michael Bridge said, you come at the end at the point of control. That's something which, by having control, actually you achieve that status of possession. It's the same thing. It's two sides of the same coin.
Mentions regarding the research model that the public of privacy and privacy is better, but it not really available because in their there will be a technical knowledge property. Not necessarily the best thing, but there might be a chance. Phone call can be decentralized. So I understand that I'm not sure whether there will be because if it's private model, then this will be.
Yeah, well, I think private blockchain will most likely replace the current central registry, because you don't pay a huge fees, because in order to become member of Bolero, it's expensive, so large companies can afford, but small business cannot. But with this kind of private system blockchain, you can see it's $15, so it's small amounts. It's peanuts money. So I think for practical reasons, this private blockchain will replace eventually this central registry. Maybe Patrick knows better.
Yeah. The private blockchain is still controlled by the owner of the platform. It's the owner of whoever can join, you can try to computer and put on the software and you try to that means opening your computer power for transactions. And the public one that is the thing that has so many advantages that I don't even know where to start. Because, for example, the private one, I don't know. Because you just have to have a control of 51% computer power and you can change it. You have to keep it in mind. In public, that can be absolutely important. Well, absolutely not, as we said before. Relatively absolutely important.
I mean, even in public, if you somehow
no, I will maybe later explain a little bit how the blockchain works and then we'll get the picture. And yeah, we have two seconds.